Do you have any new information regarding the SEC? Immediately following the conclusion of the lengthy legal battle that had been going on between Ripple and the SEC for the past month, a new request was submitted to the court. Following the conclusion of the conflict, it was determined that the trading of XRP on exchanges was allowed. The Securities and Exchange Commission brought forward a request for a penalty of $2 billion, which ultimately resulted in Ripple being fined $125 million. In response to the $125 million punishment, Ripple and the cryptocurrency market expressed their satisfaction. In spite of this, the parties were able to come to an arrangement of postponing the payment of the $120 million fine. In a petition that was submitted to the Southern District Court of New York yesterday, Ripple requested that the payment of a fine that was greater than $125 million be delayed. Within the petition, the legal team that is representing Ripple proposed that a significant portion of the penalty money, which is around $139 million, be deposited into a bank account either before the conclusion of the appeal period or within the next 30 days. Ripple's action, which was taken after the appeal was resolved and the Securities and Exchange Commission approved the request for a postponement, was interpreted as an appeal of the ruling that was given down by the SEC. The fact that Ripple elected to postpone payment of the penalty rather than pay the penalty directly, as well as the fact that the SEC granted the postponement, was viewed as an indication that the SEC was still examining the prospect of appealing the judgment. In addition, the fact that the execution of the legal process had not yet been completed made it possible for Ripple to be sentenced. Could be postponed if the court offers its formal agreement to do so in the absence of approval from Judge Annalisa Torres regarding the matter which is now being discussed. As a result, Torres advised him that the postponement would not be deemed authentic when he was questioned about the ruling of the court. The chief executive officer of Ripple, Brad Garlinghouse, describes it as a success for the company. Ripple has placed a request to postpone the payment of a fine that is equal to $125 million. Furthermore, the SCCA was in agreement with the circumstances that were proposed. As a consequence of the legal events that have taken place, this has resulted in conversations regarding the likelihood of an appeal being filed. There has not been a significant impact on the price of XRP, and according to the current market, it is still trading at approximately 55 cents. A crucial milestone was accomplished in the ongoing legal battle between Ripple and the Securities and Exchange Commission of the United States, according to the most recent information that was released at the beginning of August. In the past, Judge Torres issued an order that forced the corporation to pay a fine of $125 million for violating multiple securities regulations. This figure was a fraction of the initial demand made by the regulator, which was for $2 billion. The corporation was required to pay the fine. It would appear that a couple of Ripple's top executives, such as Chief Legal Officer Stuart Alderati and Chief Executive Officer Brian Garlinghouse, were content with the decision that was handed down by the magistrates, despite the fact that many users of X had anticipated that the company would comment on the topic. They made a commitment to comply with the regulations and pay the amount in cash from the balance sheet of the company. There has been no public remark made by either the company or the agency regarding this matter. This week could be the day when they reach a settlement with the agency. In the letter that was presented to the court 1 month ago, the legal team that is representing Ripple has just recently submitted a new motion in which they ask for a stay on the monetary component of the decision that was made by the court. It was announced by the company that the Securities and Exchange Commission had given its approval to the proposed terms and the postponement of the payment that was supposed to be made on September 6th. The entire money, which is roughly $138 million, was to be paid to the bank account of the legal team. It has been claimed that the funds would remain in the account until 30 days after the deadline for filing and appealing has gone. This is a sort of security that has been implemented. Please bear in mind that the verdict can be disputed by both sides until the beginning of October by the movie Kellogg Hansen, who is employed by Ripple and is one of the attorneys representing Ripple, until the cash is either released by a court order or through an agreement between both parties. You all make sure that it stays in the account until it is released. In the event that the Court of Appeals decides to overturn or amend the verdict, the parties will make an honest effort to come to an agreement over the best way to handle the fund, and they will present any disagreements to the court. It is impossible for them to settle, the letter states. The ultimate decision about whether or not to alter or vacate the verdict will be made by the judges. A number of people working in the industry were under the notion that this move would be a precursor to an appeal that would be submitted by Fred Raspoli, an attorney from the United States for the Securities Exchange Commission. He is one of the individuals that has communicated their level of agreement with this idea. According to the statement that he made, The establishing of a trust for the monies, which necessitates all of this labor, raises the probability that an appeal will be filed. It is my opinion that this is the most foreseeable step that the Securities and Exchange Commission might take in order to gain time before the deadline for filing an appeal on October 7th. The cross-appeal scenarios that could be taken into consideration, they have indicated their hope that the Securities and Exchange Commission (CC) may be able to submit an appeal before the restriction of 60 days, which would expire at the beginning of October. James and Mark Fagel are two of the numerous former lawyers who have worked for the SEC. An appeal could be filed by the Securities and Exchange Commission (C) in order to dispute the verdict in a more comprehensive manner. Ripple would be necessary to submit a cross-appeal to the Second Circuit Court in order to dispute the decision. If Ripple decides not to submit a cross-appeal, it will effectively accept the $125 million penalty without any further discussion. This is because there will be no further dispute. The capacity of the court to examine additional matters in the wake of the announcement of the stay requests will be limited as a result of this. Other potential problems include the following. The chief legal officer of Rippling Waves, Stuart Alder T., continues to maintain his optimism that the outcome of the case will not be significantly altered by the use of an appeal. He feels that there is a 10% likelihood that the Securities and Exchange Commission will try to overturn the ruling. Because of the lack of clarity around the Ripple SEC lawsuit, the price of XRP has been significantly impacted as a result. In addition to the fact that the coin has lost all of its recent gains, there has been a decrease of 0.67 in open interest in XRP futures, which is an indication of the dropping interest from derivatives. Additionally, the number of transactions has decreased by 15 over the course of the past 24 hours, and the current price of XRP is $0.55. Additionally, throughout the span of a few months, there has been a reduction in the quantity of XRP futures that are available for trade. There may be a sense of unease in the Bitcoin business. Holders of XRP are keeping a close lookout for a conclusion that might potentially have an effect on the cryptocurrency market in the event that the appeal is permitted to proceed. Regarding the question of whether or not the top regulator will file an appeal, the XRP community is not quite clear on the matter. The partial triumph that occurred on August 7th, they have until October 6th to fight the ruling. Despite the fact that Ripple and the XRP community have gained some success in their dispute with the SEC. This is because the time for the Securities and Exchange Commission to submit an appeal is certainly getting closer. The conflict will not be settled in the near future. In addition to this, there is a possibility that tensions would increase once more. In the future, will the situation get even more severe? Be sure to check back for further details regarding the attorney. The Securities and Exchange Commission (CC) may not have made up its mind on whether or not to appeal the Ripple litigation, according to a hypothesis that was presented by Jeremy Hogan in a recent post on X. In addition, it was brought to everyone's attention that the process of submitting a notice of appeal is a straightforward and efficient one that can be finished in just 15 minutes. The Securities and Exchange Commission would have 70 days to submit the actual brief once the notice is filed. Hogan is of the opinion that the Securities and Exchange Commission would not delay filing if they had already decided to appeal the verdict. This is especially true given that the ruling that is now in place does not favor their point of view. In light of the current circumstances, the CC and Ripple have submitted a request to have the monetary judgment put on hold. A mine plea has been submitted to the court by Ripple and the SEC in order to request a stay of the monetary element of her judgment, which is worth $125 million. This motion is being submitted only a few days before the deadline of September 6th for Ripple to pay the penalty that the court and elicitor have imposed, despite the fact that Ripple had previously stated that it had no intention of appealing the decision.